Ready, start. It is submitted that PW1 is a related witness and as such conviction cannot rest solely on the basis of his evidence. In addition, it is submitted that the offence committed by the accused appellants would not fall under Section 302 IPC and at the most the accused appellants could be convicted for a lesser offence. Per contra, Sri Akshay Amritanshu, the learned counsel appearing for the state, has vehemently opposed the appeal. He submitted that the appellants have committed the brutal murder of 3 persons. It is further submitted that the testimony of PW1 is supported by medical evidence and as such no interference by this court would be warranted. We have heard learned counsel for the parties and perused the material placed on record. The prosecution case basically rests on the testimony of PW1, who is the son of deceased Ram Avatar and nephew of deceased Namo Shankar and deceased Girja Shankar. PW1 in his statement has deposed that there was a dispute over the measurement of agricultural fields between deceased Ram Avatar and accused number 1 Raghav Prasad. PW1 stated that when he along with all 3 deceased and 2 other persons went to the agricultural field in Baruhar Ghat, they saw that the 4 accused persons were hiding there and on seeing them they came out. It is further stated that the accused persons Raghav Prasad and Dayanidhi were carrying sticks, whereas Prem Shankar had a pike and his father-in-law had a spear. The perusal of the evidence of PW1 would reveal that even though the accused appellants were having sharp weapons within bracket pike, spear, etc. bracket close, they had only used the blunt side of the said weapons. It is further to be noted that PW2 Chandrika Prasad, who is the son of deceased Namo Shankar, had turned hostile. Moreover, the medical evidence would also show that all the 3 deceased persons had lacerated and contused wounds only and there were no incised wounds. As already seen above, a perusal of the evidence of PW1 would itself reveal that the accused persons Raghav Prasad and Dayanidhi were carrying sticks, whereas the other accused persons Prem Shankar and late Ram Naresh, who were carrying the sharp weapons, had only used the blunt side of the weapons. In view of the evidence of PW1, we do not find any reason to disagree with the concurrent findings of fact recorded by the trial court and the High Court that it was the accused appellants who caused the death of Ram Shankar, Namo Shankar and Girja Shankar. However, the question that rises for our consideration is as to whether the conviction under Section 302 IPC would be tenable or whether the accused are liable to be convicted for a lesser offence. We find that though the accused persons could be said to have the knowledge that the injuries would cause death of the deceased, there is no material on record to show that they had the intention to kill them.